A conservator is a person that's appointed by the probate court, constitutional court, and they administer probate, and they also handle matters like this. And the judge of probate would administer, well, he would conduct a hearing. I just went to one, Stanford Hospital, early in the week. And judge has to determine whether or not the person is competent. And if the person is competent, he will not appoint a conservator. If the judge, after a doctor certifies that the person is not capable of managing his or her own affairs, then in that event, the judge is going to say, yeah, this person needs help, because otherwise they can be taken advantage of. And I've seen that, and that's not nice. So that's when a conservator jumps in, and then you're responsible to the court. You have to give an inventory of the person's estate, and you have to basically report to the court everything you're doing on behalf of that person. So you become an agent, as the attorney or the conservator. You become an agent of the court, and the court oversees what you're doing. It's a good thing. It's a safeguard. A conservator could jump in any time. If you have a living will, you already tell the court, I want Mary, I want Jack to be my conservator. If, for instance, Stanford Hospital initiated this conservatorship, and I understand why they did it. And so the judge, not knowing whether or not there was anyone out there in the family, was going to have an attorney who's on his list appointed as conservator. So my friend, my colleague, was close to this gentleman, and the gentleman said, look, I'll appoint so-and-so as voluntarily my conservator, so the judge didn't have to go through a hearing. But otherwise, had that not happened, and somebody who had no knowledge of this person would have been appointed. And it's still better than nothing, but you're always better to have somebody you are comfortable with. A power of attorney can be revoked at any time. So it's an agency. You give it to somebody, you can take it back, okay? Anytime. You can revoke it and appoint somebody else. Conservator, you have to go back through the court. And because it is a court order, so the court would say, okay, it was a temporary illness that caused this person not to be able to take care of his or her own affairs. That's over now, the person can function. And I will say this, the courts universally, the probate courts, are very sensitive to taking away someone's civil liberties, and that's a good thing, because we don't want to live in that type of country where people can just say, okay, well, you can't vote anymore, you can't do this, you can't do that, now you're going to do what we tell you to do. That's just not the way we operate, and the courts are very sensitive to that, and that's a good thing. Was there another question? The answer to that is sometimes. A power of attorney is good, and it can function, and most of the time it will survive a person's disability. But there are occasions where there's limitations to a power of attorney. For instance, you may want to move a person from home to an assisted living facility of necessity. You can't do that necessarily with a power of attorney. You may want the court to be involved, to back you up and to give you a little bit more oomph. It's a higher status. A conservatorship is a higher status than power of attorney. They can work together, but once a conservator is appointed, the power of attorney goes away, because now you have a court order. And the courts our court in particular, Judge Fox, a great probate judge, his father before him, and so we have a particularly good probate court. But most of them are very good that I've dealt with. Don't forget, your license may not be available. You may be in a horrific accident, or maybe you're in a place where the license got left home. I tell folks, take this living will, give it to your doctor, have them put it in the computer on the chart. That way they can bring it up no matter where you are. So I would say it's better to put it in writing in a form like this. Yeah, put down your license is fine, but your license, and then of course EMTs do look for that right away, right? They do look for that. Because if there's organs that can be donated, there's a time frame when they have to be taken. Yes, because forms do change. When I started practicing, we didn't even have those. They weren't in existence, but and then they've evolved like anything. This is a pretty good form, I think. And so yes, it's a good, and powers of attorney, it's a good idea to update powers of attorney, because if a bank, and sometimes they can be very officious, they'll look at the power of attorney form, even though it's meant to last forever, and they go, well, this was signed in 1998. Okay. And they'll give you a hard time about it. So I tell people, refresh them periodically. Okay, and then there may be other questions they may ask, whether or not the person is still alive. It's another thing. When the power of attorney, if someone passes away, the power of attorney ceases that moment, because the power of attorney only lives as long as the person lives, because it's an agency. The answer is the probate court will take a certification from the attorney or the person submitting the documentation to the probate court. So the court does not go out and do an investigation. I file an application to submit somebody's will to probate. I certify that the people that are involved, children, maybe brother, sister, other interested parties, they get notice. If I don't have a complete list, the court doesn't have a complete list. So your attorney gave you good advice. Now, if in fact you were entitled to notice and didn't get notice, you have an objection. You could notify the probate court, something's wrong here, and I want to be put on the list. The answer to that is no. The executor is a fiduciary. It could be anybody. It could be an attorney. It could be an accountant. It could be, well, years ago people used to use trust departments in banks, but that's expensive, and it's impersonal. You're better off picking a person. Maybe you have somebody in the family who's really good with finances, and you say, well, I want that person to look after my estate. They're responsible. Some people are a little scattered. We all know. We're all different. And so you know that person's going to take care of everything in a good and business-like manner. Most of the time, if it's a family situation, no, because brothers and sisters might be involved and you don't take a fee, but an executor is entitled to a fee, a fiduciary fee, yes. Absolute and total. There's got to be transparency. There's got to be transparency, and there has to be full disclosure. If there's any balking in that, and it does happen, I've seen it more than once. That's what the probate court is for. You file a petition with the probate court for a hearing, and you'll say, I don't think everything's been properly accounted for, Your Honor. And the judge will then make a decision, and usually would lean definitely in your favor to be sure that there is full disclosure. Names. I say never. Don't do it. And don't do it for a lot of reasons. Number one, you may need to put that reverse mortgage on the property, and if it's in the children's names, then in that event, you can't do it. Number two, life is messy. So suppose you have 3 kids, 1 child, and everybody has this kind of situation. There's an in-law that you're not that crazy about, and there's a divorce. Well, guess what? That 1/3 of the house is now in the pot in the divorce. One of the children has financial difficulties. What happens? That interest in the house could be attached. So don't do it. Don't do it. That's what a will is for. When you're done with using the house, then they can have it. But up until that time, it's there for you. Yeah, I would not do it. It depends. It depends on a lot of things, whether or not the information comes in a timely fashion to file the inventory. We do have to file something called a CT 706, which is an estate tax return. That verifies that it's not a taxable estate. Once that's done, you're really ready to move on to what's called the final accounting, final report. But every estate is different. Sometimes the stuff comes in slowly. Sometimes the probate court gets backed up. Should it be under a year from beginning to end? Yes. We've done them within 6 months, if everything falls into place. And again, there's small estates and big estates. If you have an estate that everything is in survivorship, husband, wife, your estate is very simple. It's like a tax purpose only estate. You file because you want to change the land records, and that could go 2 or 3 months. Yeah, but it's, if the information is in and the attorney's on his or her game, the probate court is pretty much up to date, say 9 months. They're basically the same thing. You've given up ownership. You don't own it anymore. You're out of it. And by the way, too, if you do put the house in the kids' names, you lose control. It's your house. You think it's your house. It's not your house. And so that's when you get the input from, maybe in-laws that may not be necessarily on your side. Time to put her in a nursing home. I don't want to go in a nursing home. You're going in a nursing home. We're selling the house. Well, I don't want to sell it. You've given it up. So don't do it. The answer to that is yes, it would serve that purpose, and it must be done 5 years before any nursing home care is required, or you have to apply for Title 19, Medicaid. Once again, my admonition to everybody is stay in your home, use the equity, live there, and the heck with all of that stuff. Honestly, quality of life. It's just, and you know what? People say, I have to leave my kids something. No, you don't. No, you don't. You don't. You raised them. You probably put them through college. You've helped them in 1,000 different ways. Take care of yourself, because no one's, it's the right thing to do. But I hear that all the time. I have to. No, you don't. You don't. You really don't. And obviously, I want to help our kids if we can, but not to our detriment. The answer is generally yes. You'd have to go to probate in order for an orderly transfer of the property.
And there's no way to avoid any probate?
Well, okay, there's no way to avoid probate, I guess, in general. Is that what you're saying? Honestly, no, especially when it comes to real estate, because you're in the books down in the town hall in the grantee index as far as receiving your house. So you're in that book, and it may be 40 years ago, 50 years ago. Right now, anybody doing a title search goes back into the books, and you go to the root deed, it's called, and then you bring the deed forward to the present time. And so if someone wants to sell the house, they're going to say, okay, John and Mary bought the house in 1973. Where's John? Oh, John passed away. Well, we don't know that. We need proof. So then that happens all the time. Then you have to start an estate from 30 years ago, and you ask the probate court, look, we're trying to sell the house. Can we move this up a little bit? So you create problems. Just do it in an orderly fashion. But people, they just put things aside. And then all of a sudden there's a crisis and you're running around, on a fire drill.
Depends on the organs. Not everybody has every organ in their body that's transferable. But yes, it could be. If somebody is, 105 years old, probably not. It's probably not even worth talking about. But if someone is younger and in an automobile accident, they can be a real candidate for saving multiple lives. You can, with eye donations, it's a wonderful thing to be able to give the gift of life to someone else. And all you have to do is just say, okay, I would do that. You're not going to have any use for them, so why not? Why not? But yes, more likely younger people, but not always. You never know. Well, the answer there is yes, you don't, but you do. And this is why we chose this conversation project, because you can do that. You start out in an upbeat way. Have everybody have a cup of coffee, plan it ahead of time. Because if you're doing it at the last minute when it's time to have it, then you're supercharged. And nobody is able to do this in any kind of a way. So do it ahead of time and do the kinds of things that don't seem emotional, like here's where the will is, under the computer. And here's where, did you ever hear that one before? Under the computer?
In the sock drawer.
Yeah, in the sock drawer. Yeah. So in the dryer. So I've heard them all. So when you have those conversations ahead of time, it opens up the hard conversations about intubation and end of life. And I really don't want all of you hanging around me here. I'd like to be alone. So it's a progression. And that's why we call it having the conversation. And it goes on. You don't have to have it once. You can have it lots and lots of times, because things change. Things change.
I couldn't find about terminology because sometimes we use different terminology. More technically, should be the anointing of the sick. Last rites, there are prayers in the ritual for a person actively dying. Sometimes a priest, you can receive anointing, you are just fine, or you're in the hospital. A situation we didn't mention. If you're going to have an important surgery, they're going to put you to sleep. 99% of the time you're going to wake up from the surgery, but sometimes something goes wrong, and so it's not, particularly if there's an anesthesia, that you receive the anointing of the sick. But then sometimes you're actively approaching death, and maybe the person's even unconscious. There are the commendation of the dying. That's with more last rites also, that's beautiful prayers. Or if a person has died and there are prayers, there are many prayers in different moments.